Appeal, UKI Kingsway and Westminster City Council.
And before you begin, we should tell you both that two of us are Westminster City Council taxpayers. Does that cause anybody any difficulty? We thought it wouldn't, but we thought we ought to draw it to your attention just in case you wanted to make some argument about it. The chances of your getting Westminster City Council taxpayers in this court are very high.
Yes. May it please the court, I appear for the appellant in this matter, the City of Westminster. My learned friends, Mr. Kalinsky and Mr. Wilcox, appear for the respondent ratepayer, UKI Kingsway Limited. Before I begin, two documents were handed up this morning and should be in front of the members of the court. One is a better copy of UKI's original proposal to alter the list. As my learned friends pointed out to me that the copy that is in the core bundle is rather difficult to read. The other is a further extract from Benyon on statutory interpretation, to which I may refer in due course, and which my learned friends have kindly agreed to allow me to hand up.
You're allowed to hand stuff up if we let you hand it up.
Well, yeah. I'm grateful, my lady. Westminster is, of course, the billing authority responsible for the collection of non-domestic rates in the City of Westminster. UKI is, and was back in 2012, the freehold owner of a building known as Number 1 Kingsway. And the issue that arises in this appeal is whether deemed completion date has been validly determined under Section 46A and Schedule 4A of the Local Government Finance Act 1988 in respect of three floors of that building, the third to sixth floor. The question turns on whether a completion notice dated the 5th of March 2012 was validly served by Westminster on UKI. Westminster appeals with the permission of this court against a decision of the Court of Appeal dated the 15th of June 2017, allowing UKI's appeal against the decision of the Deputy President of the Lands Chamber of the Upper Tribunal, Mr. Martin Roger QC, dated the 28th of July 2015, to the effect that the completion notice had been validly served. And that, as the court will have seen, itself was an appeal from a decision of the President of the Evaluation Tribunal.
I think you can assume that we've read the statement of facts and ensues.
I'm very
grateful. Also assume we've read both parties' printed cases and probably all the decisions in the tribunals and courts.
I'm very grateful for that indication, my lady. I assume the court has also seen the timetable that the parties have agreed.
We think it's generous. We're expecting to be finished long before 4 o'clock.
I'm grateful again for that indication. Subject to the views of the court, I propose to structure my submissions as follows. I was going to start by touching very briefly on the facts of the case and taking the court to the very few relevant documents that there are, and then look at the relevant statutory provisions. I then propose to take the court to a number of authorities which consider the concept of service of documents in a number of different contexts, both statutory and non-statutory. And my submission will be that these authorities, with one possible exception, the case of Tinkler, show that the approach of the courts, in the absence of any specific requirements or limitations imposed by the terms of the statutory or contractual scheme, is to treat a notice as having been validly served if it is received by the intended recipient.
It has been noticed that neither party has referred to the most recent case in this court about service of notices.
I see, my lady.
Sorry to put you off your stride. It was about service of contractual notices, and there may be a distinction between service of contractual notices and services of notices under statutory provisions which are unrelated to contracts. But we were quite surprised not to see it.
My lady, perhaps both my own friends and I could look at that over the short adjournment.
Yes, yes. There may be nothing in it that is of much assistance. To the extent that it's of any assistance, it's probably slightly more of assistance to you than it is to Mr. Kolinsky, but only slightly, I think. My Lord Lloyd Jones was also in the case. It's in the employment context. It's how you serve notices of termination of employment.
I'm good.
And we'd better provide the name.
Haywood.
I am about to do that. It's Newcastle
Haywood.
upon Tyne Hospitals, NHS Foundation Trust, against Haywood, Haywwood, and the neutral reference is 2018 UKSC 22. It's probably hit $1 but I don't know whether it has or it hasn't. I didn't look that up.
My lady,
This is the document, and somebody behind you can no doubt trace it and see whether it's got anything of any use at all to either of you to say.
My lady, I'm very grateful. I then, having looked at some of the authorities, I then propose to set out our reasons why we say that the Court of Appeal was wrong to allow the UKI's appeal. I'll then address the argument raised in my own friend's written case that we unlawfully delegated our functions under Schedule 4 to the 4A to the receptionist. And then finally, I'll address the point that the notice was not validly served because it was delivered to UKI by electronic means. Now, as the court will have seen, that didn't form any part of the Court of Appeal's reasons for allowing the appeal. But it was part of the reasoning of the President of the Valuation Tribunal, and it is something, and indeed the Deputy President of the Lands Chamber, it is something that is pursued by UKI in this court. Very briefly, the facts. The court has read the statement of facts and issues. The facts were never seriously in dispute and are quite straightforward. The completion notice out of which all of this arises may be found at page 204 of the bundle. Now that was, as the court will have seen, delivered in an envelope to the premises and handed to the receptionist at the ground floor reception desk, who was an employee of a company called EcoFM, which is the a facilities management company that was employed by the respondent to manage the building on its behalf. I should make it clear at the outset that the facts of the case are somewhat unusual. Westminster does not routinely serve completion notices in this manner. The reasons why it did so, insofar as they are relevant to the appeal, and they're probably not, are set out in a little more detail, paragraphs 6 to 13 of the decision of the President of the Valuation Tribunal, who, of course, heard evidence from the individuals involved. In essence, there was confusion in the mind of the council's officer as to the identity of the owner of the building. The decision of the President sets out how that confusion arose. Clarification was sought from the rating agent, but not forthcoming, and in those circumstances, the perhaps fateful decision was taken to proceed in the manner that the council did proceed.
If they'd have fixed the notice to the building, there wouldn't have been any problem with it.
Indeed not, my lady. That is quite true. In Part A of my own friend's written case, they make certain criticisms of Westminster's handling of this matter, which echo those of the President of the Valuation Tribunal. My submission, those matters are not relevant to the outcome of this appeal, which turns purely on a point of construction of the statutory scheme. So I don't propose to address the court on those.
Did they, once they had the problem, did they then serve a proper notice? Or?
My Lord, no. That
Daniel says irrelevant.
in a sense, my Lord, it is irrelevant. As one can see from the appeal that was made under paragraph 4 of Schedule 4A, perhaps if we can turn that up very briefly, which appears at page 206. This was a letter from the rating agent to the Valuation Tribunal lodging the appeal under paragraph 4. And again, I apologise, it's not, hasn't printed very clearly. It purports to be on behalf of EcoFM, but the appeal was in fact pursued by UKI before the President in conjunction with the proposal to alter the list. And the grounds of appeal that are given are that the property concerned is not capable of being completed at the date shown in the notice. The notice was invalid because it was addressed to the owner and it hadn't been validly served. So those were the three arguments that were in play. So at that stage, it seemed that there was a challenge to the completion date itself, not purely the service point. And it wasn't really until the hearing before the President of the Valuation Tribunal some 2 years later that it was entirely clear that the challenge to the completion date was not being pursued and that we really were only arguing about, at that stage, also the formal validity of the notice and the question of service. But my Lord is quite right that that step has not been taken.
It is now paying the full rate, is it?
I believe these floors are now occupied, so yes. Turning, yes, well, for completeness' sake, as I've handed it up, the proposal to alter the 2010 rating list is found at page 207, and the two matters were conjoined and appeared were dealt with together by the Valuation Tribunal. Turning to the statutory scheme, that the relevant provisions appear at tab 27 of the authorities bundle. Starting at page 219. Section 46A appears at 221. It contains a mechanism whereby a new building which is ready or nearly ready for occupation but hasn't yet been occupied can be brought into the 2010 rating list. Subsection 1 brings Schedule 4A into effect, and Subsection 2 deals with the deeming effect of the completion notice, where one is served and the building is not completed on the relevant day, which is defined in Subsection 3, the building is deemed to be completed on that day. Schedule 4A begins at page 223. Paragraph 1.1 deals with buildings that are nearly complete, and it imposes a duty on a building authority to serve a completion notice on the owner of the building which, if it comes to its attention, that the building can reasonably be expected to be completed within 3 months, and this has to be done, as my learned friends point out in their written case, as soon as is reasonably practicable upon the authority becoming aware of it, unless otherwise directed by the valuation officer. Paragraph 1.2 deals with a building that has been completed. Paragraph 2 over the page, 224, deals with the contents of a completion notice. It has to identify the building to which it relates and state the day which the authority proposes as the completion day in relation to the building. Paragraph 3 allows the parties to agree a completion date. 4 is the right to appeal on 225. A person on whom a completion notice is served may appeal to the valuation tribunal on the ground that the building has not been, or as the case may be, cannot reasonably be expected to be completed by the date stated in the notice. And that right was, of course, exercised by UKI in the present case. The time limit for lodging such an appeal is contained in secondary legislation, namely Regulation 19 of the Non-Domestic Rating Alteration of Lists and Appeals England Regulations 2009, which are found in the authorities bundle starting at page 287. It's probably not necessary to turn it up. Essentially, it's 28 days from the date of receipt of the completion notice.
Does it say the date of receipt, or does it say so?
My Lord, it does say the date of receipt. It's as I say, it's at, perhaps we should very briefly turn it up. It starts at 287. And the provision, Regulation 19 at 288, a person who wishes to appeal against the completion notice or the imposition of a Schedule 9 penalty must send or deliver a notice of appeal to the VTE so that it is received within 28 days after the date on which the appellant received the completion notice, or notice that the Schedule 9 penalty had been imposed. Turning back to Schedule 4A, paragraphs 5 to 7 are not particularly relevant to this appeal. Paragraph 8 very much is. That is the provision that deals with service. It begins with the words, without prejudice to any other mode of service. This is page 228. Completion notice may be served by a person, and then it sets out 3 ways in which service may be effected. The following points be noted in relation to this at this stage. The Court of Appeal held, and I think it's now common ground, that this provision is permissive. Parliament has in essence left it to the billing authority to decide how a completion notice is to be served on the owner. And the Court will have seen that the Court of Appeal projected UKI's contention that the opening words, any other mode of service, were to be construed as being restricted to other modes of service permitted by statute, such as Section 233 of the Local Government Act 1972, or the service provisions in the 2006 Companies Act. And that contention hasn't been resurrected on this appeal. What we say in our written case is that the opening words of paragraph 8 expressly preserve not only any other statutory methods of service that may be available to a billing authority, but it also preserves the common law principles relating to the service of notices. As we shall see when we come to look at the authorities, paragraph 8 is an example of a provision which enables the giver of the notice to shift the risk of non-receipt to the recipient. The primary modes of service set out in paragraph 8 don't depend on receipt for their effectiveness, as long as a billing authority avails itself of one of these modes of service, good service of the completion notice will have been effected.
How does the appeal provision work in there? And the appeal provision depends on receipt, as we just seen. Would you say that this doesn't depend on receipt?
Indeed, my lord. So in those circumstances where one of these three methods of service is used, the date of service is the date on which the relevant step is taken, and it is that.
When does the time for appeal run, if that depends on under the regulation?
From the regulation says from the date of receipt. So that, sorry, Mike.
Well, it may not matter, but I mean, it just seems to be a curiosity. I wondered whether there was anything in the statute about the date of the appeal.
My lord, no. It's...
Is it a necessary implication from section, paragraph 8 of the schedule, that if one of these three permitted modes of service is employed, then the notice is deemed to have been received in accordance with that, and that's what receipt means in the regulation? Is that presumably what you would say?
My lady, yes. The receipt in that context is not actual receipt. The notice is deemed served.
Being received. Well, anyway, I mean, that's probably
Yes.
the answer, but we're not concerned directly.
It doesn't really...
It doesn't arise on the facts of this case, but
problem.
In my respectful submission, that must be the way in which the two sets of statutory provisions interrelate.
It doesn't actually say so.
It doesn't say so, my lady, no. But if we look at some of similar provisions in other contexts, they don't actually spell this out either, but that is how they have been interpreted by the courts. And the Court of Appeal found correctly in my submission that this was an example of such a provision. It accepted Westminster's submission to that effect. And I don't understand, my learned friends, to argue the contrary, but they will address the court on that in due course. Paragraph 9, again, is of no particular relevance to this appeal. Paragraph 10 contains definitions, defines a completion notice, and it also gives a definition of the owner, which is of a building, which is the person entitled to possession. So that can be the freehold owner, but it obviously can also be a tenant if there is a lease in place. And the corollary of that is, that, of course, that if the hereditament has been demised for a term of less than 7 years, the official copies of the Register of Title won't necessarily tell you who the owner is for the purposes of these provisions, because such a lease is not capable of registration. Turning to the authorities on service that we have cited.
Sorry, just before you go on to that, paragraph 8c, my lady put to you the possibility that had it been fixed to the building, that would have sufficed. But would that necessarily be so? Because, as I understand it, no reasonable inquiry was undertaken.
My Lord is quite right, yes, of course. 8c can only be relied upon if the reasonable inquiry has been was undertaken. We've never hung our hat on that. We've accepted the situation as it is, so yes, provided reasonable inquiry had been made.
Well, we don't know. We don't have any facts about whether... We know you asked them and received unhelpful response, but you could have searched the Register of Title. I'm sure that's what prompted my Lord's inquiry.
My lady, that was, if one looks at the slightly more expanded version of the facts that's in the President's, the Valuation Tribunal's decision, the authority did have, Westminster did have the office copies. The confusion arose because there was another document in existence which, to be fair, didn't really have any official status, but which appeared to indicate that the owner was a different company, actually a company that didn't, in point of fact, exist, but a different name was given, and that gave rise to the confusion. Now, it may well be fair to say that there shouldn't have been any confusion, but there was, and that is why this particular approach was adopted. My learned friends, coming on to the authorities, my learned friends to make the point in paragraph 63 of their written case that there is no general common law of service which applies without modification in every statutory context. And of course, I accept that. Ultimately, it's right that the question whether or not good service of a notice has been effected turns on the precise terms of the statutory or non-statutory scheme pursuant to which the notice is served. However, I do say that it is possible to derive certain general principles from the authorities, three in particular, where one is dealing with a scheme which imposes mandatory requirements with regard to the service of notices. Those requirements must be adhered to. Service otherwise than in accordance with those requirements will not be valid service. Where the relevant scheme contains, as it does in the present case, permissive provisions relating to the service of notices, good service will be effected if the giver of the notice adopts one of the primary methods of service laid down by those provisions, regardless of whether the notice is actually received by the intended recipient. And then in all other cases, or in all cases other than where a mandatory regime applies, good service will have been effected if the notice emanates from the giver and is actually received by the intended recipient.
However long that takes.
Yes, and of course in a time-critical context, that may be too late. So in the present case, if the notice hadn't been received until after the completion date specified in the notice, then it wouldn't have been a valid completion notice because the completion notice has to specify a date under paragraph 1.1, has to specify a date in the future. Similarly, in the case of a break option in a lease, if the notice is not received until after the critical date, then of course it won't have the desired effect.
But your submission is that service would have been effective, but the notice wouldn't have been.
The notice will not have the effect that it was intended to have, either terminating the lease or fixing the completion date.
But it would still have been valid service.
It would have been served. It would just have been served too late.
Yep.
I propose to take the authorities in chronological order, and I won't refer to all of the ones that we have referred to in our written case. The first, in point of time, is Sun Alliance and Hayman, tab 50, page 521. This is a decision of the Court of Appeal. It was actually concerned with the formal validity of a notice under Section 25 of the Landlord and Tenant Act 1954. What had happened was that the landlord had used an out-of-date prescribed form, and there was that would still have been fine if the out-of-date form could be said to have been in substantially the same form as the new form, the new prescribed form. And there was a difference between the two. One referred in terms of the time which the tenant had for service of the counter notice. One referred to 2 months from the date of the giving of the notice, and the other to receiving it. And so the question was whether there was a difference between those two, so that the notice could not be said to be in substantially the same form. The majority of the Court of Appeal held that there was no such difference when a notice was served in accordance with Section 23 of the Landlord and Tenant Act 19 27, which is incorporated into the 1954 Act by section 66(4). And the wording, or an excerpt of the wording of section 23 of the 27 Act, may be found at the bottom of the page 522, page 178 in the report. Provides that any notice under this Act shall be in writing and may be served on the person on whom it is served, either personally or by leaving it for him at the his last known place of abode, or by sending it through the post in a registered letter addressed to him there. There are three judgments. The first is that of Lord Justice Stevenson, and he deals with the nub of the matter at page 527, 183 in the report, starting halfway down A.
What's the electronic page, please?
Sorry, my lord, 527.
527.
In my judgment, the effect of section 66(4), which is the section that incorporates section 23 of the 27 Act, is that a notice under the provisions of the Act is both given and received when it is served in accordance with section 23 of the Act of 1927. And to anyone who knows the law, the time when it is given and the time when it is received are one and the same, namely the time of service when the giving of the notice is in law complete. And the learned Lord Justice further down in C refers to the time when this two-sided act is done is the time when it is deemed to be done by the statutory provisions as to service. The tenant cannot say that he has not received it when the Act says that it's been served on him. The effect which a court of law must give to the different words in order to see whether their effect is substantially like is their true effect in the context of landlord and tenant. Mr. Justice McKenna, over the page 528, dissented. He made a general observation starting at E. A notice is a notification of making known a communication of some matter by one person to another, and in the ordinary way a notice is not received until the person to whom it is to be communicated becomes aware of the matter. In other words, he receives the notice when the matter is brought to his attention. Where the notice is given personally, the giving and the receiving will, as a rule, be simultaneous. The notice will be received at the same time as it is given. But where, as here, the law provides that a notice may be given in other ways, and he sets out those ways, the view might reasonably be taken that the giving and the receiving may not be simultaneous, that the notice will be given when the document is left at the tenant's house or delivered by the postman, but that it will not be received until the tenant actually becomes aware of its existence. And his point essentially was that it's potentially confusing to the tenant who has to decide how long he has to serve his counter notice. Finally, Lord Salmon agreed with Lord Justice Stevenson, added some observations on his own. He says at 529, according to the ordinary and natural use of English words, giving a notice means causing a notice to be received. Therefore, any requirement in a statute or a contract for the giving of a notice can be complied with only by causing the notice to be actually received, unless the context or some statutory or contractual provision otherwise provides. Statutes and contracts may often contain a provision that notice may be served upon the person by leaving it at his last known place of abode or by sending it to him there through the post. The effect of such a provision is that if notice is served by any of the prescribed methods of service, it is in law treated as having been given and received. The next authority in point of time is Townsend Carrier's Pfizer, which was the subject of a significant amount of discussion in the courts below. It appears at tab 53, starting at page 556. It's a decision of the then Vice-Chancellor, Sir Robert McGarry, and the facts were that the plaintiff had demised some commercial premises to the defendant, and throughout, which contained a break option, and throughout the tenancy, the parties had left it to two associated companies to conduct any dealings between them in relation to the tenancy, so demands of rent, other correspondence in relation to other matters to do with the property. Now, neither the claimant nor the defendant had ever expressly appointed those associated companies as their agents. By letter dated the 7th of August 1975, the associated company of the tenant gave notice to the associated company of the landlord to determine the lease, and the landlord contended that the option hadn't been validly exercised because it hadn't been given by the defendant as tenant to the claimant as landlord. The Vice-Chancellor sets out at page 363 in the report 558 in the bundle the essential question which he had to decide. And this is about 2/3 of the way down the page at the end of, just before start of the final paragraph. He says, apart from the question whether the notice was given by the right person to the right person, no attack has been made on its validity. So that was the essential question. And we see the argument advanced by counsel for the landlord, Mr. William Blackburn, at over the page at 364. Sorry, my lord.
I was just noticing that Mr. Blackburn confessed and avoided. It's the fate of counsel on so many occasions.
Indeed. His essential argument was set out at page 559. In those circumstances, said Mr. Blackburn, this is the circumstances where the parties had left their entire dealings in relation to the property to their associated companies. The maxim quid facet per alium facet per se has a just and beneficial operation. Townsend's has stood by and allowed its associated company, Wilkinson's, to deal with the demised premises as if they belonged to itself. Similarly, the defendant, with the acquiescence of Townsend, stood by and allowed Unicliff to deal with the demised premises as if it was itself the tenant. Wilkinson Transport and Unicliff have acted inter se as if they were indeed the landlord and the tenant respectively. In those circumstances, Wilkinson Transport was clothed with full authority by Townsend's to act as agent on behalf of Townsend's in relation to the reversion of the demised premises, and Unicliff was clothed with full authority to act in relation to the tenancy. And that is ultimately the basis upon which the Vice-Chancellor decides the case. He accepts that submission and says at 562, he expresses his conclusion right at the end. In my judgment, if a landlord and tenant have expressly or by implication each respectively consigned the whole conduct and management of the reversion of the tenancy and of the tenancy itself to agents on their behalf, then in general what is done in relation to the tenancy as between the landlord's agent and the landlord's tenant will be as validly done as if it had been done between the landlord and the tenant themselves. So that was the finding of a general agency was the basis for the decision in the case. In the course of his judgment, though, the learned Vice-Chancellor deals with a submission made by counsel for the landlord that, to the effect that, sorry, I did say earlier that Mr. William Blackburn was counsel for the landlord. He wasn't, he was counsel for the tenant, I apologise. A submission made by counsel for the landlord that the notice hadn't been given to the landlord as such, and this, we can pick this up at 560, right at the bottom of the page. There's discussion of a case called Hawtree and Beaufront. And then the Vice-Chancellor goes on to say, this last case gave rise to some discussion before me on the distinction between addressing a notice and giving a notice. I do not propose to explore this at any length. Clause 4C of the lease says nothing about addressing a notice. The requirement is merely that the party concerned shall give to the other party 12 months previous notice in writing of such its desire. If one party were to deliver to the other party a notice which was not addressed to any named person, but simply stated, I hereby give you notice, and so on, I do not see why that should not suffice to comply with the lease. And then he goes on further down that paragraph to deal with Mr. Speed's submission. He says, I shall therefore forbear from saying anything more on the subject of addressing the notice, but then he goes on to deal with the submission of Mr. Speed that clause 4C of the lease required the tenant to give notice to the landlord. And he said that although the landlord had ultimately received the notice, no notice had ever been given to the landlord as such. However, I do not think that a requirement to give notice is one that excludes the indirect giving of notice. The question is whether the notice has been given, not whether it has been given directly. If the notice emanates from the giver and reaches to the ultimate recipient, I do not think that it matters if it has passed through more hands than one in transit. Now that was something I relied upon below, and it was accepted by the Deputy President of the Lands Chamber, that absent specific restrictions on the mode of service in the statutory scheme, there was no reason why he should adopt a different approach in the present case.
There is an earlier passage which you haven't read, in which the judge addresses the notice being addressed to the wrong person.
My Lord, yes.
And that may have a bearing on this case as well.
Well,
it's earlier in page 366.
There was an issue earlier on in this case, my Lord, because your Lordship may recall that the owner was...
I understand it's not said it was it's not said that it was addressed to the wrong person, but nevertheless it may have a bearing on the issue we have to consider.
My Lord, yes. The Vice Chancellor says if the notice was addressed to the wrong person, was nevertheless delivered to the right person, the question would be whether the misaddressing prevented the notice from being given to the right person. The purpose of a notice is, of course, to convey information, and if the notice, despite its being misaddressed, suffices to convey the requisite information to the right person, I would have thought that it would satisfy the terms of the lease.
Thank you.
I'm grateful. There was a point taken below that the notice should have been addressed to UKI by name, because of course it was addressed to the owner, but that wasn't pursued beyond the upper tribunal. In the Court of Appeal, Lady Justice Gloucester distinguished this case on the grounds that it was concerned with the situation in which a notice was served by a de facto agent of the tenant on a de facto agent of the landlord. In my respectful submission, that is not a relevant point of distinction. In the passage relied upon, the Vice-Chancellor was addressing the submission by counsel of the landlord that as a matter of language, the notice could not be said to have been given to the landlord because it had passed through the hands of a third party. And his rejection of that argument was not premised on his finding that there had been a general agency. The issue simply doesn't arise when one is in an agency-type situation, because if there is an agency relationship between the intermediate and the ultimate recipient, in those circumstances, good service on the agent, the intermediate recipient, is good service on the principal. The next relevant authority is Fagan and Knowsley Metropolitan Borough Council, which is at tab 37, page 382. Again, decision of the Court of Appeal, and this was a case concerned with the service regime contained in Section 30 of the Compulsory Purchase Act 1965. And this is an example, or was held to be an example, of a mandatory code. It was conceded by the local authority in this case that service had not been effected in accordance with Section 30. In effect, what had happened was that the notices in this case, under the Compulsory Purchase Act, had been delivered to the landowner's brother. The landowner was out of the country, and his brother looked after the land for him. the local authority contended that despite the failure to comply with Section 30, that good service had been effected because it had been served on a duly authorised agent of the landowner. That was accepted by the Lands Tribunal, citing the decision in Townsend's, and we see that page 365 of the report, where Court of Appeal, Lord Justice Balcombe, sets out an extract from the decision of the member of the Lands Tribunal. The Court of Appeal allowed the appeal and held that Section 30 contained a complete mandatory code for the service of notices, which did not permit service on an agent, and therefore Townsend's did not assist the authority. In my respectful submission, that is an unsurprising decision. And one that doesn't assist UKI either in this context, because we're not dealing with a mandatory code, a complete and mandatory code, from the provisions of which it is not possible to escape, as Lord Justice Balcombe put it on page 366. Moving on then to Galinsky and McHugh, tab 38, page 387. I apologise for the quality of the copy of the report. The print is quite small because it's from the Estates Gazette law reports.
All these copies are distinctly difficult to cope with. The way in which they've been scanned, I think, has meant that they don't come out very clearly. But
Yes,
we'll do our best.
it is just about legible, I think.
Well, those of us who are looking at it electronically can magnify it. So where do you want us to look?
Well, this case was concerned with the service of a notice under Section 4 of the Landlord and Tenant Act 1954. These are the provisions in Part 1, which deal with residential tenancies rather than the more familiar provisions in Part 2 relating to business tenancies. The landlord served a Section 4 notice on the tenant proposing a statutory tenancy following an abortive enfranchisement claim. A notice was sent to the tenant's solicitors, who were held to have ostensible authority to accept service. And the argument advanced by the tenant was that the notice had not been validly served because Section 23 of the 1927 Act, which the court will see set out at page 389, 111, the report in the judgment of judgment of the court delivered by Lord Justice Slade. Right at the top of the left-hand column, the full wording of Section 23 is set out. Again, that is a permissive service provision. And the argument, the ingenious argument by the tenant was that service on the agent wasn't valid because the section specifically referred to service on the agent of a landlord, specifically permitted service on the landlord's agent, applying the principle expressio unius est exclusio alterius, service on an agent of the tenant was not permitted. That was rejected by the Court of Appeal. If I can pick up Lord Justice Slade's judgment at 111b, he says, having set out Section 23, and he refers to the argument of the tenant, he says, there is no doubt that in some instances, a statute on its true construction will mandatorily require the service of a notice in a particular manner and no other manner if the notice is to be valid, subject to the possible operation of estoppel. This court held that to be the effect in relation to Section 30, and then there's a reference to Fagan and Knowlesley, and an excerpt from the judgment of Lord Justice Balcombe. There are at least, Lord Justice Slade goes on, there are at least obvious distinctions between the wording of Section 23 of the 1927 Act, which prefaces the modes of service referred to in the permissive may, and the wording of Section 30 of the 1965 Act, which in two places uses the imperative word shall. It would seem that in Fagan this court might have held that service was ineffective even if the agent had passed on the notice to the owner of the land, since the question whether he had or had not passed on was apparently never canvassed. The position under Section 23.1 is different, at least to this extent. Mr. Zellin, counsel for the tenant, accepted that a notice under Section 23.1 will be effectively served if in the end it comes into the hands of the person entitled to receive it, even if it is not served in any of the modes expressly authorised by Section 23.1. Well, that was clearly accepted by counsel for the tenant, but the Court of Appeal doesn't appear to have disagreed with that proposition. He refers to a decision of Mr. Justice Wynne Parry in Stylo Shoes Prices Taylors, which was not, the correctness of which was not challenged, and then there's a reference to a passage in Halsbury's statutes as authority for the proposition that as Section 23.1 is permissive only, it is clear that where a notice is served in a different manner and is received, this constitutes good notice. To this extent, he accepted that Section 23.1, unlike Section 31 of the 1965 Act, does not afford a complete code. Nevertheless, he submitted the general purpose of Section 23.1 of the 27 Act is to ensure that a notice is received by a person who is entitled to receive it. A mode of service on such a person not expressly permitted by the subsection will suffice, if but only if it results in his actually receiving the notice. Any mode of service not expressly permitted by the subsection which does not have this result, so the argument runs, will be invalid. And then the Lord Justice sets out his conclusion slightly further down. In our judgment, this last submission involves a misunderstanding of the nature and purpose of Section 23.1 of the Act. This is a subsection appearing in an Act which, like the 1954 Act, contains a number of provisions requiring the giving of notice by one person to another and correspondingly entitling that other person to receive it. In our judgment, the object of its inclusion in the 27 Act and its incorporation in the 1954 Act is not to protect the person upon whom the right to receive the notice is conferred by other statutory provisions. On the contrary, Section 23 is intended to assist the person who is obliged to serve the notice by offering him choices of mode of service which will be deemed to be valid even if in the event the intended recipient does not in fact receive it. And then it goes on to describe the modes of service. In our submission, which the Court of Appeal accepted, this is the sort of provision that we're dealing with in the present case. The next authority is tab 51, Tadema Holdings and Ferguson, page 531. This was to do with service of notices under the Housing Act 1988. And the question was whether a notice of increase of rent pursuant to Section 13 of that section had been validly served on the tenant. It formed the basis for a possession claim based on non-payment of the increased rent. The tenant argued that the notice was not valid for a variety of reasons, one of which was that it hadn't been, and also that it hadn't been validly served because he had lacked mental capacity at the time that service was effected. It was said that it was not possible to serve a notice on a person with a mental disability who was incapable of dealing with it. That submission was rejected by the Court of Appeal. Lord Justice Peter Gibson, with whom Lord Justice Ward agreed, commented on the meaning of the word serve right at the end of the report, page 538, which I rely on. Second paragraph, counsel for the tenant frankly acknowledges that there's no authority on the point. It seems to me that what the court must do is construe the meaning of the word serve in Section 8.1 and Section 13.2. I do not think it can be said the meaning of that word is different in relation to service on a patient from that which it would have in relation to service on a person of full capacity. Serve is an ordinary English word connoting the delivery of a document to a particular person. and it's Westminster's submission that it should be given its ordinary meaning in the context of Schedule 4A as well. London and Frogmore Investments, tab 35, page 307.
I'm sorry, tab.
Tab 35, my lord, page 307.
Thank you.
That was a decision of the Court of Appeal to which Lord Carnwath was a party. It arose out of somewhat unusual facts, namely the bombing of the Arndale Centre in Manchester by the IRA. Structural damage to the demised premises in question was such that the landlord decided to invoke a right under the lease to determine the tenancy. And it sent notice pursuant to the relevant clause in the lease and the Section 25 notice, because the tenancies were within the Act, to the tenant at his last known residential address, and also affixed copies to the premises. The notices had been sent in the post were returned by the post office. And the appeal proceeded on the basis that the tenant did not have actual knowledge of the notices prior to the expiry of the relevant time limit. In the first instance, it was held that the notice had been validly served and the tenancy therefore validly determined. The tenant appealed to the Court of Appeal. Lord Justice Robert Walker gives the most substantial judgment, and he makes certain general observations, what he describes as general observations of an elementary nature, at paragraphs 26 through to 28. This is at page 315. He says at paragraph 26, notice is not the same as knowledge, but the evident purpose of requiring notice to be given to a particular person is that the contents of the notice should be communicated to and become known by that person. Nevertheless, there's no doubt that both statutory and contractual provisions may lead to the position that a valid notice has been given even though the intended recipient does not know of the notice and is not at fault in not knowing it. This point was very clearly made by Lord Justice Slade in Galinsky and McHugh, which we have just looked at. Paragraph 27, in his oral submissions, Mr. Kim Lewis and QC described these provisions as being concerned with the allocation of risk, that is, the risk of a notice being given by a recognised procedure, but nevertheless failing to achieve its purpose of communication because of some mischance, such as those exemplified in the authorities. And paragraph 28, Lord Justice Robert Walker goes on to say he accepts that that is one of the purposes, to establish a fair allocation of risk. And he says the other main purpose is to avoid disputes on issues of fact, especially as to whether a letter went astray in the post or was accidentally lost, destroyed, or overlooked after delivery to the premises of the intended recipient, where the true facts are likely to be unknown to the person giving the notice and difficult for the court to ascertain. So there are the sorts of provisions that we're dealing with in the present case serve two purposes. One is to shift the risk of non-receipt, and the other is to avoid disputes of fact. Now, of course, in this case, there has never been a dispute of fact about the actual receipt of the notice by UKI, albeit in electronic form. I would just point out in passing that some reference is made to a decision of the court in paragraph 34, to a decision of the Court of Appeal in Chiswell and Griffin Land and Estates, a passage from the judgment of Lord Justice McGaw, which, this is at the bottom of page 317, which I just ask your lordships to read, the court to read. Moving on then to the next authority, which is one cited also cited by the Court of Appeal and relied upon by my own friends below, is that of the decision of the Court of Appeal in Glen International and Triple Rose, which is at tab 39, page 391. Both Townsend and Galinsky and McHugh are referred to in this case in the judgment of Mr. Justice Munby, as he then was, with whom Lords Justice Jacob and Tuckey agreed, at least in relation to the first, what was described as the first argument, and that was the question, the essential question for the Court of Appeal in that case was whether a letter sent by landlord's agents to the tenant's solicitors was a valid notice pursuant to Section 48 of the Landlord and Tenant Act 1987, which is the provision that requires a landlord of premises to which the Act applies to furnish the tenant with an address in England and Wales at which notices may be served on him. The question was, first of all, whether the letter relied upon was a valid notice for the purposes of Section 48, and second, whether it had been validly served. It was held that the letter was not a valid notice for the purposes of Section 48. We see that in paragraph 16 of Mr. Justice Munby's judgment. And that really was sufficient to dispose of the appeal. But Mr. Justice Munby then goes on to consider what the position would have been if the letter had constituted notice. He goes on to, he concludes at paragraph 22 that even if it had not been given to the tenant because it had been sent to the tenant's solicitors, who did not have authority to accept service on the tenant's behalf. Now, at paragraph 22, the learned judge records that counsel for the tenant, Mr. Zellin again, relied on a number of cases involving a service by a landlord solicitor or other agent, or a tenant solicitor or other agent. And that includes Townsend Carriers. And unsurprisingly, it was said that didn't assist the tenant, because in those cases there were findings that there had been, the recipient of the notice had authority to receive it. So in my submission, it is, although it's not clear from the judgment precisely what part of the Vice-Chancellor's reasoning in Townsend's was relied upon, in my submission it is clear, because of the issue that the Court of Appeal was considering, that it was the agency point.
It was never argued that it had come to the attention of the tenant.
My Lord, that is exactly the point in relation to this authority, that it was not argued that good service had been effected because the notice had been passed on by the solicitors to the tenant. We don't know from the report, from the judgments, whether that had in fact happened. Even if it had, it wasn't argued that had resulted in good service. And that is why I submit that this authority doesn't assist UKI, even though it distinguishes Townsend's. It distinguishes Townsend's on a different point. Lady Justice Gloucester, in her judgment at paragraph 52 in the Court of Appeal, did consider that this case assisted UKI, because she said that it was implicit in the judgment of Mr. Justice Munby that onward transmission would not have rendered ineffective service effective. My respectful submission, it can't be said that is implicit in the judgment. The point simply was not considered. Another case relied upon by UKI below and in this court is the decision of Mr. Justice Gross, as he then was, Atlantic Sugar and Baffin, which is at tab 43, page 432. So it starts. It's not a report, so the facts were somewhat complicated. The question for the court was whether arbitration proceedings in relation to certain bills of lading had been commenced in time. And in time meant that notices had to have been served on the facts by the 12th of March 2009. We see that from paragraph 10 of the judgment. The person on whom the notice of arbitration had to be served was the claimant Baffin, and we see from paragraph 8 that it was incorporated in Barbados, where it had its principal and registered office, and it also had registered offices in Hong Kong and the Marshall Islands, and in the Marshall Islands it had a registered agent. There were associated companies involved. Both, we see at 8.4, both Baffin and FIL were part of the FedNav group. And there was also a PI insurance club involved. What happened was that on the 6th of March 2009, a notice of arbitration was sent to FIL and the PI club, but not to Baffin. And then, following a telephone conversation about which there was a dispute of fact as to what was said, further notices were sent on the 12th of March 2009 to FIL and the club. And in response to those notices, we see paragraph 19, it was said that neither FIL nor the club had authority to accept service on notices on behalf of the owner of the vessel, Baffin. Now that prompted a response from Atlantic Sugar. At page 21, we see that at that point, copies of the notices were dispatched to the Marshall Islands and Hong Kong, and also to Barbados, but they all arrived too late. So the argument was, we see the rival contentions of the parties set out at paragraph 32, page 441. The argument was concerned whether the 6th of March and the 12th of March notices, first of all, whether they had been served in time, and secondly, whether, if they hadn't, whether an extension of time under section 12 of the Arbitration Act should be granted. And the argument that was being advanced by counsel for the claimants was, as we see at 32.1, that the notices had been validly served because Baffin knew about them. It knew that Atlantic Sugar was in the process of wanted to commence arbitration proceedings because of the communications that had taken place between the relevant individuals. And knowledge was said to be sufficient. The contention at paragraph 34 set out contention for Baffin was no, for service of these notices to be properly effected, would have had to have been served either on Baffin itself or upon an agent with actual or ostensible authority. Mere knowledge on the part of Baffin that the claimants were floundering was not the same as or sufficient for proper service. And Mr. Justice Gross accepted that submission. He deals with the first issue, paragraph 37 onwards. Paragraph 38, he deals with sympathy, which didn't get Atlantic Sugar very far. And then, although the judge had considerable sympathy for it,
Never does.
well, it did. Well, least of all in the context like this, one would have thought. But there we are. Paragraph 39. He accepts the submission of counsel for Baffin that the claimants were required to serve Baffin itself before the expiry of the applicable time limit, notwithstanding the flexibility inherent in the provision, it didn't go so far as to satisfy the need to serve Baffin properly and within time. Paragraph 40, this is a passage that's relied upon by my learned friends and was cited by Lady Justice Gloucester in her judgment. The learned judge says, thirdly, again, as Mr. Kulkarni correctly submitted, Baffin or the FEDNAB group's knowledge that the claimants were floundering does not equate to good service. The requirement was that the claimant should serve Baffin before the expiry of the time limit, not that Baffin should be aware that the claimants were trying to do so. If a claimant is required to serve X and mistakenly purports to serve Y, the mere fact that Y informs X of the purported service so that X knows of it cannot convert Y's receipt of the documents into good service upon X. Now, in my submission, that doesn't assist UKI. That is not this case. I don't rely on the fact that UKI knew of the existence of the completion notice. I rely on the fact that it actually received it. And the principle that Mr. Justice Gross formulates here at paragraph 40 is entirely consistent with the principles that emerge from the other cases, that it is the actual receipt of the notice which constitutes service. Finally, a further decision that my learned friends rely on, which is Tinkler, tab 52, starting at page 539. This is a decision of the Tax and Chancery Chamber of the Upper Tribunal, which was handed down after the decision of the Court of Appeal in this case. It concerned an appeal by the taxpayer against a closure notice, inter alia on the grounds that HMRC had not validly given him notice of their intention to opening an inquiry into his 2003-2004 tax return. And it was accepted that if no valid notice opening the inquiry had been given, then the closure notice was not valid, would not be valid either. The notice had been sent to an old address at which the taxpayer no longer lived, and a copy of it was sent for information purposes to the taxpayer's accountants, BDO. And BDO had told the taxpayer and or his personal assistant that an inquiry into the 2003-2004 tax return had been opened and had proceeded to respond to it. But it doesn't appear that the notice, the actual document sent by HMRC, was passed on to either the taxpayer or to his PA. So this again seems to be a case where the taxpayer could be said to be aware of the notice but not actually having received it. The First Tier Tribunal rejected HMRC's argument that BDO had had actual or ostensible authority to accept service on behalf of Mr. Tinkler, but it found in HMRC's favour on the grounds that Mr. Tinkler's PA had had actual authority to receive notice of the inquiry on Mr. Tinkler's behalf, and that she had received such notice when BDO told her about it. And the First Tier Tribunal also held that there was an estoppel by convention. The taxpayer appealed, and HMRC cross-appealed against the finding that BDO had not had actual or ostensible authority. On that point, the Upper Tribunal allowed the cross-appeal.
Where do we find this?
My lady, the...
Tab 52.
The decision of the, starting at paragraph 22 of the judgment of the Upper Tribunal.
What did you say? Which page number?
Page 543.
543, thank you.
Oh, I apologise. Did I not give the page
No,
number?
you never did. So I've been listening to what you've been saying in sublime ignorance of what you're talking about.
I apologise, my lady. The judgment starts at 539, and we see the decision of the FTT summarised at 543 onwards. So both the taxpayer and HMRC appealed. And the upper tribunal deals first with the cross appeal from paragraph 33 onwards to 545. And it allows the cross appeal, it concludes actually on the facts that BDO had both actual and apparent authority to accept service of the notice of inquiry. And that effective notification therefore occurred when HMRC had sent a copy to BDO, and the fact that that had been for information purposes didn't matter. And we see that in paragraph 46. Now that was sufficient to dispose both of the cross appeal and the appeal. But the tribunal does go on to deal with the other issues. Principally the estoppel argument, which is dealt with at paragraphs 49 to 68, which I need not trouble the court with. And then finally, from 69 onwards, the tribunal considers Mr. Tinkler's argument that the FTT had been wrong to conclude that good service had been effected because BDO had told him and or his PA that HMRC had opened an inquiry. And the tribunal agreed with Mr. Tinkler on this, although, of course, it didn't do him much good. Key paragraphs are 70 and 71. We agree with Mr. Thomas that Section 9A of the relevant statute is prescriptive and that it requires HMRC to give the notice of an intention to open an inquiry to the taxpayer or his properly authorised agent. Mr. Thomas was also correct to say that it is Section 115.2 that is relevant. In the case of an individual, the subsection permits HMRC to give the notice or other document by serving it by post addressed to the taxpayer at his usual or last known place of residence or his place of business or his place of employment. It follows from Section 7 that if the notice is not properly addressed, then the notice does not become properly served, simply because someone forwarded it to the intended recipient, or the intended recipient learns of it from some source. Accordingly, we consider that the FTT was wrong to conclude that valid service under Section 9A was given when, as the FTT found, BDO told either Mr. Tinkler or his PA of the notification of the inquiry before the inquiry window closed. It follows from our conclusion on this point that it is not necessary for us to consider whether Mr. Tinkler's PA was his agent. There is no evidence to suggest that whether or not she was Mr. Tinkler's agent, Mr. Tinkler's PA actually received the notice from HMRC, and in our view, it could not be enough that she was told by BDO that there was an inquiry. And then we want to say, similarly, we do not need to consider the findings of fact in relation to the role of Mr. Tinkler's PA, nor do we need to consider the burden of proof, as it is irrelevant whether BDO, having received the notice as Mr. Tinkler's agent, and notice having thereby been given to Mr. Tinkler, told Mr. Tinkler or his PA about the inquiry. Furthermore, even if contrary to our conclusion, BDO was not Mr. Tinkler's agent for the purpose of receiving notice of the inquiry, then those matters would still be irrelevant, as HMRC would not have given notice to Mr. Tinkler or his agent, and neither the mere forwarding of the notice nor Mr. Tinkler's knowledge of it, whether personally or through the agency of his PA, if one were found, could constitute valid notification. Now, those last observations do appear to support UKI's case. What I say in relation to them is, well, first of all, their obiter. On the facts of the case, it doesn't appear that the notice was in fact forwarded by BDO to Mr. Tinkler and his PA. They were merely told about it as in Atlantic Sugar. And insofar as the upper tribunal considered that forwarding would not have resulted in valid service being effected, I respectfully submit that it was wrong. I would also point out that it's inconsistent with the authorities to which I've already taken the court. The approach taken in those authorities, particularly the dictum of the Vice-Chancellor in Townsend, which doesn't appear to have been cited, or indeed any of those authorities don't appear to have been cited to the upper tribunal, and no real reasons are given for that conclusion. It's simply stated boldly as the conclusion. That concludes my review of relevant authorities, subject to my looking over the short adjournment at the recent decision of this court. And if I have any submissions to make on it, I'll do so at the end. Turning to the decision of the Court of Appeal, the crux of Lady Justice Gloucester's reasoning is set out at paragraph 44, which one finds at page 154 of the order. I imagine the court has read that passage.
In its original form and in the cases.
Indeed, my lord, yes. Lady Justice Gloucester is, of course, right to point out in that passage that paragraph 1 of Schedule 4A requires effectively three things. First of all, that a completion notice be served, that it be served by the billing authority, that it be served by the billing authority on the owner of the building to which it relates. Now, in relation to the first element, as I've already submitted, the word serve, there's no good reason to give the word serve in Schedule 4A anything other than its ordinary meaning, and whether it means nothing more than adopting the formulation of Lord Salmon, Sunderland and Hayman, causing a notice to be received, or whether one adopts the formulation of Lord Justice Peter Gibson in Tadema, Holdings and Ferguson as the delivery of a document to a particular person.
What do you say about the point that this is a taxing statute and the notice has to be given promptly?
Well,
You're going to come to that.
I'm going to come to that. I'm happy to deal with it now if that...
I'm happy for you to take your course.
I'm very grateful. So the word serve, when it is used in this statute, my submission should be given its ordinary meaning. A completion notice, a billing authority has to cause a completion notice to be delivered to the building owner as soon as reasonably practicable, upon it becoming aware that the building can reasonably be expected to be completed within 3 months. Now, in the present case, there's never been any dispute that the completion notice was delivered to and received by UKI, albeit in electronic form. The Court of Appeal appears to have considered that the second element, namely that the completion notice has to be served by the billing authority, was not satisfied in the present case, because it had passed through the hands of the receptionist, whom Lady Justice Gloucester points out in that passage, was neither authorised to accept nor authorised to effect service on behalf of, wasn't authorised to accept service on behalf of UKI, and wasn't authorised to effect service on behalf of the billing authority. Now, as to the first of those points, it's never been Westminster's case that the receptionist was authorised to accept service, so that good service could be said to have occurred the moment the notice was handed to the receptionist. It's always been our position that the relevant chain of events doesn't end there, and that the fact that the notice did find its way into the hands of the intended recipient was therefore acted upon, and was thereafter acted upon, that can't be ignored.
You rely on the fact that the receptionist, the nature of things, was a reasonable chance that she would pass it on. I mean, do you distinguish this case from a case where, say, the notice has been put into a dustbin and the landlord happened to be, the intended recipient happened to be passing and found it there, so there's no real sort of causal connection?
Well, in the case, if the notice has been put in the if your Lordship is positing a scenario where the billing authority thinks better of serving the notice and...
I'm just saying that the receptionist gets it and does throws it in the wastepaper basket, and it happens by pure chance that the recipient or the intended recipient happens to be passing and happens to see it in the wastepaper basket and picks it up. So there's complete happenstance that finds its way. Does that make any difference?
Well, I do accept that the notice has to emanate from the giver. It is the giver who has to cause the delivery of the notice. to the intended recipient. And it might be said in the scenario that your lordship posits, that in that situation there is a break in the chain of causation, because the steps taken by the billing authority effectively come to an end the moment the notice disappears in the dustbin, and thereafter it is pure happenstance that it finds its way into the hands of the intended recipient. In our written case, we do also give the example of a situation where the notice is the person commissioned with the delivery of the notice by the billing authority mistakenly puts it through the letterbox of the next door property as a result of some confusion. The occupier of the neighbouring property, realising the mistake and being helpful, then puts the notice through the door of the correct property, and it is then received and acted upon by the intended recipient. In those circumstances, I would submit that there isn't a break in the chain of causation, that it can still be said that the giver of the notice has caused the notice to be delivered to the intended recipient.
The essence of your case is that it was received by UKI. I mean, when my lord puts to you that it's relevant that there was a reasonable chance that ECO's receptionist would convey it to UKI, in a sense, that's not relevant. I mean, the essence of your case is that UKI got it.
My lord, yes.
I wonder, I mean, that's what I'm trying to test, whether there are limits to that. And I understood you were saying there are limits, and there is a test of a necessary causal link. Is that right?
Yes, there has to be a causal link, my lord. I accept that, because the requirement to serve, as Lord Salmon puts it in Hayman, some lines in Hayman, the giver has to cause the notice to be served.
Well, I suppose you could have a notice that was sitting in the offices of, say, Westminster City Council, somebody having forgotten to do anything with it, and some officious bystander sees that sitting there, nothing having been done with it, picks it up and puts it in the post or does whatever they want to do with it. You might say that Westminster City Council hadn't caused the document to be served, but you don't need to go anywhere near that.
My lady, I don't. The example, I gave a somewhat similar example in front of the Deputy President of the Lands Chamber, where I posited a scenario where the official of the council draws up the completion notice. On a hot summer's day, the window is open. He leaves it on his desk, momentarily goes away to get a drink. The fan blows the completion notice into the street, where it is picked up by a helpful passerby who then delivers it to the intended recipient. In those circumstances, one might again say, the council was not the first unmoved mover. It didn't set in motion the process. It
was merely a passive participant in those circumstances. It didn't take any active participation in its service. And it occurred to me to think about whether Westminster Council had an officer who had one of his children with him on Bring Your Daughter to Work Day, and they went to the offices of UKI, and he, in order to encourage her to participate, handed it to her, and she actually served it. Would that be effective service? You say yes.
Provided it's actually received, my lord, yes.
Yes.
It's not intrinsically different from giving it to the postman. It's a very high-risk strategy, and if the notice doesn't reach the intended recipient, then, of course, the billing authority has a problem, and that is why it is always a good idea to use one of the primary methods of service identified in paragraph 8. But in your lordship scenario, yes, it would most certainly be my case.
But on Lady Justice Gloucester's analysis, that would not be effective service.
My lord, no. And indeed, my scenario of the helpful neighbour would not be effective service either.
If we're being asked to lay down some principles, I assume, in this case, and I'd quite like to know how you define you accept that there is a causality test or element. It'd be quite helpful if now or later in the day you could define it with a little more precision, because I don't think it would be very helpful for us just to throw out sort of sensible examples.
My Lord, no, indeed.
Well, in a way, how much discussion is helpful in something that isn't in any case your case?
Well, I would like to hear what the case
Sorry.
is, and I would like
You're
an answer. I mean, he can say he doesn't want to tell me,
entitled.
but I would like, if he can, to define his causality test.
Well, I think your answer may be that provided there's active participation, well, hang on, that provided there's active participation by the serving authority and service is effective, that's sufficient.
My Lord, yes. If the authority takes steps which ultimately result in the notice coming into the hands of the intended recipient, if it emanates from the authority and it is received by the intended recipient, then that is good service, and it matters not that it has passed, as the Vice-Chancellor put it in Townsend's, it matters not that it has passed through the hands of a third party. The example that my Lord Carnwath originally gave with the dustbin momentarily caused me to pause for thought, because in that scenario, it seems there might be more of an argument for saying that the relevant chain of events comes to an end when the notice disappears into the dustbin. On reflection, on my case, I think if one takes my case to its logical conclusion, the notice in those circumstances must be treated as effectively served. So in effect, as the formulation of my test, I am adopting the words of the Vice-Chancellor in Townsend's. If it emanates from the sender and is received by the intended recipient, then good notice has been effected.
But emanates wouldn't require any positive action at all on the part of, this is my Lord's point.
Well, my Lord, with respect, it would, because the billing authority obviously has to draw up the notice, and it has to take the first step to send the notice on its way out into the world. If the notice, my lady, the example given by my lady the President, that if the notice is left by the relevant officer on his desk, perhaps because he didn't intend to serve it at that moment in time, and it is picked up, the decision actually to set in motion the process of service was taken by an officious bystander, unconnected with the council, then in those circumstances, it can't be said to have been served by the council, because the council didn't, at that moment in time, intend to take steps to serve the notice. I do take issue with the formulation that is found in that is adopted by my learned friends, but ultimately comes from the President of the Valuation Tribunal's decision that the notice reached the intended recipient more by luck than judgment. I do submit that that is not a fair characterisation of what happened. We didn't hand the notice to a complete stranger. This isn't a sort of message in a bottle type scenario. We handed it to an employee of the respondent's agent, tasked with looking after the building. And it was not unreasonable of the council's officer to suppose that she would act conscientiously and pass it on to the building owner. Now, Lady Justice Gloucester makes the point in her judgment that, as I've already indicated, that the receptionist was not authorised by Westminster to effect service on its behalf. That wasn't a point that had particularly features as part of the case until the Court of Appeal handed down its judgment, I think it's fair to say. So there are no findings in the lower tribunals about precisely what was in the mind of the officer of the council when he handed it to the receptionist. But in my submission, as a matter of common sense, the completion notice was plainly handed to the receptionist with the intention that he or she, history doesn't recount, should pass it on to the building owner. And in doing so, in my submission, Westminster must be taken to have impliedly authorised the receptionist to do so. To suggest that Westminster handed the notice to the receptionist but somehow didn't confer authority on her to pass it on doesn't, in my respectful submission, really make sense. That was the whole point. It obviously wasn't addressed to the receptionist herself. But even if that's wrong, it's not necessary on my case for there to have been authorization. I submit that the actions of the receptionist, even if they were unauthorized, didn't break the chain of causation that Westminster set in motion, resulted in the notice being delivered to the intended recipient and fulfilling its statutory purpose. And there is nothing in the wording of Schedule 4A that requires, in my submission, the courts to adopt a more restrictive approach to service than that. And that brings me on to the policy imperatives that my Lord Kitchen referred to a moment ago, which have always featured very prominently as part of UKI's case, understandably, and also feature in the decision of the Court of Appeal at paragraph 49, where Lady Justice Gloucester in essence accepts my learned friend's submissions on that point. Now, of course, it's true that this is a taxing statute and that certainty and precision are important in that context, but I would submit that they are also important in some of the other contexts that we've just looked at, in the context of statutes that regulate property rights, such as the Landlord and Tenant Act 1954 and the 1988 Housing Act, and in private contractual arrangements. In none of the authorities that I've taken the court to, did the courts consider that a test based on actual receipt by the owner introduced an unacceptable level of uncertainty or friction into the system. And I submit that the same is true here. Whether or not a building owner has received a completion notice is simply a question of fact. There's never been a dispute about that question of fact in this case. Of course, it is true that disputes can arise. The recipient may deny that the notice was received. And then, of course, the burden would be on the billing authority to prove that it had been. But Parliament has come to a billing authority's rescue and it was plainly alive to this risk because it provides in paragraph 8 for certain modes of service which, as we have seen, shift the risk of non-receipt onto the recipient. But crucially, it chose not to make any of those modes of service mandatory. It could have done so, as it did in Section 30 of the Compulsory Purchase Act 1965, but it decided to leave it to the billing authority. So, in relation to the point made by Lady Justice Gloucester, paragraph 49 of her judgment, I say that my case does not introduce an unacceptable level of uncertainty and friction. There is a mechanism in the statute for achieving certainty, it just isn't compulsory. In my own friend's written case, at paragraph 58, they identify three policy imperatives. The first I have dealt with, certainty and precision. The second is the point that my Lord Kitchen referred to, namely speed. And it is true that paragraph 1 requires a billing authority to serve a completion notice as soon as reasonably practicable after becoming aware that the building can reasonably be expected to be completed in 3 months. And of course, in light of that requirement, billing authorities would plainly be well advised to adopt one of the primary method of service identified in paragraph 8, as that will ensure, as we have seen, that service is effected on the date that the relevant step is taken. What I submit, though, is that the requirement to act as soon as reasonably practicable isn't a basis for reading restrictions and qualifications into the statutory regime, which have no basis in the language used. It doesn't follow from the requirement to act as soon as reasonably practicable that Parliament must have intended that good service would not be in fact effected in cases where the billing authority does not avail itself of one of the primary methods of service, but the notice is nevertheless received by the building owner without any significant delay. That, in my submission, simply goes too far. The third policy imperative, identified by my learned friends at paragraph 60 and 61 of their written case, is the preservation of the principle that professional advisors may act for their clients without being authorised to accept service of notices on their client's behalf. And what is being said is that our interpretation would effectively abolish this principle and would place advisors in an invidious position. I say that is misconceived. An advisor who does not have authority to accept service of notices on behalf of his client, in circumstances where that advisor is nevertheless sent a notice, it is open to him, her, subject to taking instructions from the client, to send the notice back with a covering note saying, we do not have instructions to accept service, and that the notice should be sent to the client direct. So it doesn't collapse that distinction at all. It may be that the advisor's, the instructions that the client gives to the advisor is, well, please pass it on, in which case good service has been effected, and then that's the client's decision. Equally, the notice can be returned, in which case good service, if it's not passed on, good service has not been effected. And I would respectfully submit that as far as the policy considerations are concerned, the Deputy President of the Lands Chamber got it right when he said at paragraph 46 of his judgment, which appears at pages 169, 170 of the bundle, that in a case such as the present, where the vital information has successfully been imparted to the person who needs to receive it, and that person has acted upon it, that the policy considerations relied upon by UKI are not sufficiently powerful to require its liability for rates to be determined on a counterfactual basis, that it never received the information in question. I now move on to the unlawful delegation point. Now that is a new point raised in this court. It wasn't argued at any of the stages below. UKI points out that, quite rightly, that Westminster, as a local authority, cannot delegate any of its functions under Schedule 4A without express legislative authorisation. And what it contends is that the giving of the completion notice to the receptionist for onward transmission to UKI amounted to a delegation by Westminster of its functions under Schedule 4A, or indeed, or part of those functions, without legislative authority, and was therefore ultra vires. In my respectful submission, that is not correct.
It's not very attractive at first sight.
No, well, the relevant functions of a billing
You say this was first, it hasn't figured before.
No.
Tends to be a giveaway if it hasn't.
Well, in fairness to my learned friends, it flows, as I indicated earlier, the point that the receptionist was not authorised by Westminster to effect service on its behalf, that came from Lady Justice Gloucester in her judgment. And in some senses, the point that my learned friends are now taking can be said to flow on from the authorisation point. So for that reason, no point is taken on the fact that it is being raised late in the day. But it is wrong. The functions of the billing authority under Schedule 4A in the present case were discharged by Westminster itself. Westminster determined, first of all, that the completion notice should be served. Westminster drew up the completion notice, and Westminster caused the completion notice to be delivered to UKI. And again, the fact that it passed through the hands of a third party in transit doesn't constitute delegation by Westminster of any of its statutory functions. The involvement of the receptionist was purely ministerial. It was purely a ministerial handling, which is no different from, in essence, no different from the ministerial handling of the postman. And of course, it can't be suggested that if Westminster had put the notice in the post, that it was delegating its functions to the Royal Mail. I have identified one authority which is not referred to in a written case because it doesn't deal with this point, but is in the bundle, which considers delegation in a rating context, which may be of assistance to the court. It's a decision of the House of Lords in Provident Mutual Life Assurance, Derby City Council. It's at tab 46 of the bundle, 478. Apologise. This was a case concerning a completion notice, albeit under the predecessor legislation. And the essence of the facts were these. The local authorities, the council had delegated, passed a resolution, delegated the running of the rating scheme to its treasurer. And the treasurer had signed a blank completion notice, which was then copied and completed by the council, by the authority's principal rating assistant, as and when he decided that it was appropriate to serve a completion notice. The decision to serve the completion notice, the decision to the determination of the completion date specified in the notice, all those decisions were made by the rating assistants without any involvement of the treasurer. And it was argued by the ratepayer that this involved an unauthorised delegation. And the House of Lords disagreed. There were there were a number of issues, one of which was whether there was a power to delegate at all to the treasurer, and that is not relevant for the for the present purposes. That the relevant passages are in Lord Roskill's speech, with whom Lords Wilberforce, Simon, and Keith agreed. Lord Bridge dissented. Lord Roskill deals with the no power to delegate argument at 486, 181 in the report, at B through to D. And then at D, he turns to other matters. Perhaps rather than reading it out, if I could ask the court to read from 181D down to the end of Lord Roskill's speech on 182. Again, a dim view appears to have been taken of the practice of the local authority. But the conclusion of this, the final paragraph I rely on in particular, that what happened in that case did not involve delegation of the statutory functions. And my point in relation to this case is simply, well, if that didn't involve delegation of statutory functions, then certainly handing the notice to the receptionist to pass it on to the building owner surely cannot have done so either. Insofar as, finally, on that point, insofar as there was an act of delegation, properly so called, then I submit that it was authorised by Section 111(1 of the Local Government Act 1972, which appears in the authorities bundle at tab 25, page 213. My submission, it was something that was plainly calculated to facilitate or was conducive or incidental to the discharge by Westminster of its functions under Schedule 4A. And in this regard, I note that UKI appears to accept paragraph 52 of its written case, that the use of a process server would be covered by section 111. In my submission, this is not intrinsically different from that. That leaves the final point that I have to deal with, which is the use of electronic communications. Now, that was not something that it was necessary for the Court of Appeal to express a concluded view on, and Lady Justice Gloucester didn't do so, although it is fair to say that at paragraph 54 of her judgment, page 157, she did indicate that she was minded to accept my learned friend's argument on that point, which is based on the Electronic Communications Act, which I shall come to in a moment. The tribunals below took differing views on this issue. The President of the Valuation Tribunal considered that the recipient of the completion notice was entitled to receive the original unless it had indicated a willingness to accept electronic service. That's paragraph 38 of his judgment at page 179. And the Deputy President of the Lounge Chamber took the view that in circumstances where there was no dispute that the notice had been received by the intended recipient, there was no justification for distinguishing between notices in different forms. Paragraph 49 of his judgment, page 171. I submit that the Deputy President was right, starting first of all with the wording of the statute. There is nothing in that wording stating the obvious that prohibits the service of a completion notice by electronic means. In fact, paragraph 8 is expressly prefaced with the words any other means, modes of service, which are about as wide as it is possible to get. The use of electronic communications, I submit, may reasonably be supposed to have been within Parliament's contemplation at the time of passing the 1988 Act, because obviously fax was...
What evidence do you have about that?
Well, I have the case of fax was already widely in use by then.
Lots of authority about fax.
Indeed, and then one of the authorities I refer to, which is from 1990, Hastie and Jenkinson and McMahon, where the Court of Appeal decided that fax could be used for service under the rules of the Supreme Court. Certainly, the view was taken that fax was sufficiently widely used at that stage, that should be regarded as acceptable. Now,
Yeah, but you're not here talking about fax. I mean, it's not as if a fax, if you had sort of sent a fax saying, I've got this notice here, this is what it says, that would be slightly different than actually scanning a copy of it, emailing that.
well, the end result, my Lord, is exactly the same. The recipient receives an exact duplicate of the notice.
The actual notice, yes.
That which was intended to be
You
sent.
don't under a fax, you don't.
Oh yes, no, a facsimile could have been sent of the notice. The notice could have been played into the machine and received.
Yes. Oh yes, sorry, yes.
Yes, that is what one would imagine.
A long time.
The difference between fax and email for these purposes, of course, that the intended recipient doesn't get a paper copy unless they click print and the PDF is printed. Whereas with a fax machine, of course, what comes out of the machine is a paper copy. But in my submission, nothing should turn on that. Now, of course, I accept I'm not suggesting that service by email would necessarily... email was not, but it may have existed in 1988, but it certainly wasn't in common use. But as the court will appreciate, obviously statutes are generally treated as always speaking. In other words,
Especially in the field of technology, I should think.
well, my lord, indeed, the court, except in exceptional cases where it's clear that this is not the case, the court must interpret and apply them in the world as it exists today. And in the world as it exists today, or indeed as it existed back in 2012, email is a well-established means of communication and of transmitting documents. Indeed, it has eclipsed fax as the means for doing so. In my submission, therefore, applying that principle, the words "any other mode of service" in paragraph 8 should be construed in 2018 as including electronic communications, a means of communicating, as including email, provided that the use of such electronic means result in the intended recipient receiving a legible copy of the notice. In my submission, applying the principles as emerged from the cases, it should be treated as having been validly served. And that was the approach adopted by the Court of Appeal in a case I've already referred to, Hastie and Jenkinson and McMahon. The report may be found at page 401 of the bundle.
Which tab is that?
Forgive me, my lord, I didn't write it down in my notes.
I've got
it's
it,
tab
40. Yeah.
In this case, the Court of Appeal was concerned with service of a list of documents pursuant to an order made by a master under the rules of the Supreme Court. And the list had been served by fax, and the question was whether that was valid service. And I have in our written case set out in full the passages that I rely upon from the judgments of Lord Justice Wolfe, as he then was, and Lord Justice Glidewell. The court may already, therefore, have read them. The passage...
We have.
Indeed. Lord Justice Wolfe asks the question, are there any legal reasons why advantage should not be taken of the progress in technology which fax represents to enable documents to be served by fax, assuming this is not contrary to any of the rules of the Supreme Court? Now, of course, if it had been contrary to the rules, then there could have been no question of it being valid service. It wasn't held to be contrary to the rules. What Lord Justice Wolfe says at the end of the passage in question, which appears at 405 at the bottom, is that in cases where no particular degree of ceremony is required, in an ordinary case, in order to comply with an order such as was made by Master Hodgson in this case, I see no reason why there should be a need for ceremony. What is required is that a legible copy of the document should be in the possession of the party to be served. This fax achieves. I therefore conclude that service by fax can be good service subject to any requirement of the order requiring service of a particular document and any requirement of the RSC. And that is the approach that I submit should be adopted here. And I've set out the passage from Lord Justice Glidewell's judgment, which I say is consistent with the earlier authorities that we have looked at, particularly his point at 411, that if a document is served by a means for which neither the rule nor the statute provides, there will only be good service if it can be proved that the document in a complete and legible state has indeed been received by the intended recipient. There was also a judgment from Lord Justice Lloyd, who was considerably less enthusiastic about the decision, but did not dissent. I have also referred in my written case to the decision of Sir Andrew Morritt, then Vice-Chancellor in P&C Telecom, and Thomas, which is at page 448, tab 44. That again was in a statutory context, and the decision is of particular interest in relation to my own friend's argument, because this too was an area of law in which the appropriate minister had exercised the power under Section 8 of the 2000 Electronic Communications Act to make provision in relation to some areas of company law, but not others. And provision hadn't been made in relation to notices served under, which is what this case was concerned with, Section 368 of the 1985 Act, whereby a shareholders of the company can require the board to convene an EGM. And the argument advanced by the company was that the EGM had not been validly requested because the statute required it to be deposited at the registrar's office either by post or in person, and it had been sent by fax. And that was not permissible. We see from the judgment that some reference there was, if I can pick it up at paragraph 14 of the Vice-Chancellor's judgment, page 452, reference was made to the exercise of the Section 8 power, which we'll come on to in a moment, in relation to a number of provisions under the Companies Act. And the Vice-Chancellor says, just below B, it is noteworthy that no amendment has been made to Section 368. Equally, an amendment was made to Section 253, but not to either Section 214 or 377. And then he goes on to say, referring to some other provisions, he says, now the Council was able to suggest the basis on which some of these provisions have been singled out for amendment, but others not. We find ourselves in the same position here, in that the power has been exercised in relation to some provisions of the rating legislation, but not, as my own friends rightly point out, in relation to completion notices. And I'm not aware of the explanation for that. The conclusion that the Vice-Chancellor reached as a result, following review of a number of authorities, including Hastie and Jenkinson, paragraph 22, he says, there is no doubt in this case a hard copy document was physically present at the registered office of PNC on November the 8th, 2002, which purported to be, and subject to the second point, was a requisition in accordance with Section 368. It is not suggested that anyone was misled or disadvantaged in any way because of the means of transmission. I can see no reason why such means of transmission cannot give rise to a deposit for the purposes of 368. The ultimate result is exactly the same as if it had been transmitted in person or by post. And that, of course, is the case here. And my own friends rely on the fact that the power under Section 8 has been exercised in some areas of rating law, but not others, crucially, completion notices. And it's said that this demonstrates that the use of electronic communications is not permitted under Schedule 4A. Lady Justice Gloucester was attracted to that submission, but didn't need to decide the point. In my submission, it is based on a mistaken understanding of how the 2000 Act operates. If we can turn to that, the relevant provisions are at tab 29. And that what this does, it gives...
Page, please.
Sorry, my lady. 240.
Thank you.
What this does is confer a power on the appropriate minister by order to modify the provisions of any enactment or subordinate legislation or any scheme, license, authorization or approval issued, granted or given pursuant to an enactment or subordinate legislation in such a manner as he may think fit for the purpose of authorizing or facilitating the use of electronic communications or electronic storage for any of the purposes mentioned in subsection 2. Subsection 2 sets out those purposes. Subsection 4 without the prejudice to the generality of subsection 1, the power to make an order under this section shall include power to make an order containing any of the following provisions. And then there's a long list of provisions. And I would draw attention to the fact that at M, it is provided that any such provision, that is a reference to the foregoing provisions listed in A to L above, in relation to electronic communications or electronic storage, the use of which is authorised otherwise than by an order under this section, as corresponds to any provision falling within any of the preceding paragraphs that may be made where it is such an order that authorises the use of the communications or storage. So the point to note in relation to this is that the Act doesn't impose and doesn't purport to impose a general prohibition on the use of electronic communications, except in those cases where the Section 8 power has been exercised. It clearly is also concerned the power can be used in relation to those cases where the use of electronic communications is authorised pursuant to other provisions. And that power can be authorised either can be used either for authorising or for facilitating the use, or obviously for both. Now, in a case where the power has been exercised, then of course the use of electronic communications will be regulated by the relevant order. And unless the provisions of that order are adhered to, service by electronic means will not be valid. In areas where the power has not been exercised, service may still be validly effected by electronic means, provided that the use of such means is not contrary to the provision of the relevant enactment or pursuant to which the notice is served, and provided that it results in the intended recipient receiving a legible copy of the notice itself. My learned friends submit that the power in Section 8, as I understand it, can only be used, was intended to, and can only be used to widen the use of electronic communications, not narrow it. One doesn't get that from the wording of Section 8. It can be used, the power can be used for the purposes either of authorising or of facilitating. The term facilitating, in my submission, is a very wide one, which is plainly capable of covering the imposition of requirements that are considered desirable, such as a requirement to obtain consent before electronic communications are used, but which have the effect of narrowing the circumstances in which electronic communications may be used under the relevant enactment. That could still be characterised, in my submission, as facilitating the use of electronic communications, even though it potentially restricts the freedom of the giver of the notice, because it imposes, it's intended to impose protections for the recipient. So in my submission, Section 8 and the 2003 order made pursuant to it does not, do not stand in Westminster's way as far as service by electronic means is concerned.
Was the Court of Appeal referred to PNC Telecom?
It was, my Lord, yes. I'm fairly sure it was.
Never mind, but she doesn't comment.
I think...
Well, don't worry now.
Yes. Unless I can insist further.
Just a point which may or may not matter, but you referred us earlier to the 2009 regulations at page 288 and to the reference there to receipt.
My Lord, yes.
I've been trying to find the sort of primary statutory source of that particular regulation, and I failed to do so. If someone can
I don't immediately have the
No,
answer.
I mean, I checked on the ones which are listed on page 287, but none of them seem to me to have anything to do with appeals against non-completion notices.
I should look at that over the shorter term.
Don't spend too much.
Thank you very much indeed, Mr. Cockler.
On behalf of the respondent, I would propose to deal with matters in the following order. There's 4 parts. Part 1, very shortly, a few observations on the facts. Part 2 is probably the most substantial part, which is the features of the statutory scheme to support my core proposition that the expansive approach to indirect receipt that was introduced by the Deputy President in the upper tribunal and underpins the appellant's case is inconsistent with a number of features of this statutory scheme properly understood. The third part of my submissions will be to address why it is I say that the appellant's analysis and indeed the Lands Chamber's analysis doesn't work, and just to foreshadow that, it's that there isn't a clear answer to the question that my Lord Lord Carnworth articulated, which is where's the stopping point to this? What is the limit here to where this doctrine of indirect receipt takes us? And I say that raises significant alarm bells in this particular statutory context for reasons which I will develop. And then fourthly, it's to focus on it from a policy perspective. And the points have been canvassed, but there are 3 policy points that I say are strong indicators against the expansive approach in this statutory context. They are the need for certainty. And one element of that I'll point out is that this is not a bilateral context only, because somebody else has to act on a completion notice, a valuation officer. And that valuation officer needs to know exactly when the completion notice date is triggered, and to understand precisely when service has taken effect in order to make that judgment. So that's the certainty element. The second element is a short point on speed. And then the third one is that the upshot of the analysis is that it fundamentally erodes the distinction between professional advisors who are authorised to accept service and those who are not, and also places those who are not in an invidious and undesirable position. So that's the shape of the argument on behalf of the respondent. In relation to the first part of that, the factual questions, I've got 3 short points to make. The facts are very simple. They're set out clearly in the agreed statement of facts, and there's little for this court to be troubled by in terms of understanding that. But I do want to just draw attention to 3 points. The first point is, and it hasn't featured in my learned friend's oral argument, but it's very, in my respectful submission, it's important to understand that actually it is a mischaracterisation to say that the argument in this case is about relief from liability from rates. It's actually about whether a statutory precondition for the imposition of rates arises in the first place. And that's in a context where, contrary to the general principle of rating that you rate according to the reality of the position, this is a mechanism for rating on an assumed basis, and that assumed basis is against the interests of the ratepayer, deeming something to be complete, either confirmatory, which is one element of the notice, or the type of notice we're concerned with here, on a deeming basis where it is not in fact complete in terms of the principle of reality.
As a matter of interest, how many sort of months or of liability hang on the result of this appeal?
Well, the answer to that is it's a matter of pure chance, but it's the period between effectively it's the period prior to occupation, but my lord, I'll come on to why that hangs on that as my next point.
How long is that?
Approximately 2 years. But my second point, an absolutely critical part of this factual context, is that this putative ratepayer alerted the billing authority to the problem way before the deemed completion date. So the challenge to the service dates to the end of March 2012. the 29th of March 2012, and that's paragraph 20 of the Statement of Facts and Issues, tab 4, page 45. So in time, that is within 3 weeks of the date on which, on the council's case, the notice was served, but which we challenged. It's 2 months before the deemed completion date. So on a worst case scenario, if action had been taken, we wouldn't be in litigation about 2 years. We would be in litigation about 1 month if the council had adopted a plan B that they might not have had valid service. So that's the factual context. And that's why we say that this is a quirky set of facts, because as we say in paragraphs 9 to 11 of our case, it is fair to characterise the facts of this case that Westminster have, in 2 respects, been the author of their own downfall, if their downfall is what follows. Firstly, because there's no good reason why they didn't use one of the statutory methods of service. And can I just help the court in relation to the observation right at the outset of my Lady Hale that this could have been affixed to the to the building.
Subject to the question of whether they'd made reasonable.
Yes, and the fact that it was subject to that question was pointed out by my Lord Kitchen. But may I give one other reference that throws some colour on that, which is if you go to paragraph, just very briefly, to paragraph 37 of the Court of Appeal's judgment, which I'll give you the page. I've got the page reference in. So that page reference is A149. You'll recall that the statutory precondition under subparagraph C of paragraph 8 was that reasonable inquiries had been made. Now, it was common ground before the Court of Appeal not only that none, sub-Roman 2, that none of the specific modes had been used, but also that the name and address of the appellant as owner of the building could have been ascertained by the respondent as a result of a reasonable inquiry. So the argument proceeded on the basis that that statutory precondition had not been met because they hadn't made the reasonable inquiries. Had they made reasonable inquiries, there wouldn't have been doubt. So, my lady, that's just to place that.
That's one way of putting it. Another way of putting it is, this is not worth arguing about, that they did make the reasonable inquiries, but for some reason they didn't have the strength of their own conviction as a result of the reasonable inquiry.
Well, that's a matter that is canvassed in the at first instance.
Yes,
but well,
Professor Zellick.
My understanding of the concession that's recorded at 37.3 is that had reasonable inquiries had been made, as opposed to inquiries that were ineffective but not reasonable, then the true owner could have been ascertained, and that is consistent with findings that were made by the President. But my lady, with respect, I don't think the outcome of this appeal is going to turn on that hypothesis. But I just try to complete the factual picture in that respect. The second point is a point I've already made, that had a plan B been put forward when the challenge was made, then we simply wouldn't be here, because there wouldn't be a dispute worth the amount of money that it is.
But that particular circumstance can't affect the principle at stake here, surely. I mean, if a second notice had been sent, notwithstanding your client's refusal to divulge their name, apparently, or gave instructions to JLL that their name should not be divulged, that is by the by, surely. I mean, the principle is the one that we have to focus on.
We do, but it's contextually relevant only to a limited extent. That the problems that flow from this case, in terms of what might be perceived as any unattractiveness of a large amount of money turning on a service point, is, I would respectfully submit, mitigated by the fact that this is not a case where the ratepayer takes a late service point years after the event, and the technical point in that respect. It's a point that was flagged early on.
Well, it's a forensic point.
Well, it's a contextual point, my lord, but it's... but then that may be in the eye of the beholder. Anyway,
Well,
that's...
forensic points are there to be taken, but so long as we understand the contours.
Anyway, that's all I propose to say in relation to part one, the facts. The facts are easily ascertainable, and those are just the features that I draw to the court's attention. The most substantive part of my submissions, that's going to straddle, obviously, the 10 minutes now available and after the short adjournment, is the points on the statutory scheme. And may I just, there are 5 points that so if I can start by just encapsulating what those 5 points are, and then I'm going to put flesh on the bones of each point in turn to the extent that it's hopefully useful to do so. So the first point is that that section 46A and schedule 4A create a statutory mechanism for imposing liability for non-domestic rates on a deemed basis. And that because this is a building which is not in fact ready for occupation for the purposes for which it's constructed, but is to be treated as such if the statutory mechanism is put into effect. Now, that statutory mechanism, as we'll see when we look at section 46A subsection 2, deems completeness in 2 respects. One is entry into the rating list, but the other is that it is valued as if complete. So it's both the satisfying of the precondition for liability and also the creation of a liability on an assumed basis that the building is in fact complete. So it's a double disadvantage to a ratepayer in that respect. And also, as I will indicate, it's a mechanism that actually needs to convey precise information to another public officer, the valuation officer, who is responsible for maintaining the rating list, and that's an added element of the certainty argument. So that's the first point is the deemed taxation point. The second point is, I say, and my learned friend doesn't, as I understand it, dissent from this, that Lady Justice Gloucester was right to identify 3 elements of service. It's not just service of the notice, that's the middle requirement, but it's the billing authority shall serve the required completion notice on the owner. And that's the statutory language bears that out. And I say that there are features of the statutory scheme which are particularly relevant to that first requirement, is what happened here in these unusual facts, service by the billing authority. And it's that point where the features of the statutory scheme in relation to delegation come in, not as a freestanding point, but as an indicator of elements of that statutory scheme. And I'll show the court the relevant provisions and develop the submissions in relation to that briefly. The third feature in the overview is that this statutory scheme, properly understood, is, I say, highly regulated in terms of the scope for the billing authority delegating its function of serving a completion notice to a third party. And this element, I respectfully submit, arises out of the appellant's response to what I submit is the valid observation that what happened here was not service of Lady Justice Gloucester, that what happened here was not the reception passing on, the receptionist, the Eco-FM receptionist, passing on the electronic copy of the notice to the respondent was not service on the part of the billing authority, because they were not acting as the billing authority when they did that. And the answer to that brings this point into heightened relevance is that the appellant's case is, and I'll quote it and I'll then show you it in the context of developing this point, but the appellant's case is that the council must have been taken to have impliedly authorised the receptionist to serve the notice on its behalf. That's the way the argument's put in the notice of appeal and in the appellant's case. And I say that that argument doesn't sit with the restrictions in the statutory scheme on the delegation of this to an external party. My submission will be that there is a distinction between an authorised agent of the council, for example, a process server, and the circumstances of this case, where on any view, the receptionist was not an authorised agent under the control of the billing authority. And it's that absence of control which is the critical distinguishing feature that says, on these facts, this is not service by the billing authority. So the feature of the statutory scheme is the extensive regulation on the lawfulness of delegation. That's a fact. At this point of the argument, that's a factor against the expansive approach to indirect service.
Was implied authority the way the upper tribunal put it?
Well, the upper tribunal, with respect to them, ducked this point, and Lady Justice Gloucester focused on it. In fact, actually, if you trace the argument through, my lord, there's an element of recognition of the importance of it being serviced by the billing authority in parts of the precedent of the valuation tribunal's judgment. The deputy president in the upper tribunal followed the merits as he saw them in paragraph 46 of his decision. I'll come to this in a few moments, but he effectively recognised all of the certainty issues, but then said they don't apply in the circumstance of this case when it was in fact received. The insight that Lady Justice Gloucester brings to that is that when you focus in on the position of the receptionist, we know the receptionist isn't, as a matter of fact, authorised to accept service on behalf of the respondent, but also she can't possibly be, I'd respectfully submit, authorised to effect service on behalf of the billing authority. And it's Lady Justice Gloucester who brings that insight, and I respectfully submit important insight, into the analysis. And it's the appellant's answer to that there is implied authorisation that gives rise to the emphasis in this court on the statutory scheme, that assertion does not fit in this statutory scheme.
Well, there's a difference, isn't there? It may not be important here, I'm not entirely sure, but it seems to me there is a very big difference between my saying to my accountant, you are authorised to accept the revenue's communications designed for me,
Yes.
On my behalf, and basically to deal with them. And my saying to a messenger boy or a carrier pigeon or whatever, please transmit this document from A to B. These are different sorts of activity.
My submission will be that the critical limitation on whether it can be an act on behalf of the billing authority is the extent to which the billing authority has control
Yes,
over
you've
it.
said that, yes.
And I'll make that point by I make it my written case. I'll make it by reference to the case of Credit Suisse. And I say that's the analytical limits on what can be seen to be control on behalf, service on behalf of the billing authority.
Yes, you're probably in more control of the carrier pigeon than you are in control of the receptionist.
Well, I leave open in my submissions whether the carrier pigeon is an authorised agent. Maybe, but,
No, I'm saying it's not. I'm saying it is merely a means of transmission.
yes. Yes. But,
Like Wi-Fi.
So if I could just complete the identification of the 5 features in the last 2 minutes. So the third one, which we slightly digressed from, was the highly regulated scope for delegation. The fourth one, which I will need to make submissions on, is that this statutory scheme is highly regulated in respect of the use of electronic communications, and critically, it only authorises the use of e-billing, e-service of notices, in a context which is A, bilateral, in other words, the service of a bill from a billing authority to a ratepayer, and B, consensual. And in that statutory context, the wide indirect receipt that's relied upon by the appellant does not fit, I say, in the overall statutory scheme. And the fifth point is the wrap-up, that given those four features of the statutory scheme, the expansive concept of indirect receipt doesn't fit with this particular statutory scheme, and I will also say at other stages of the argument will cause significant uncertainty and difficulties in its practical operation. So where we are at this stage of the submissions is I've identified those 5 headings on my part 2 points on the statutory scheme, and after the short adjournment I'll develop each one of those in turn before then moving on to the other parts of the argument.
Thank you very much indeed. Well, we'll look forward to hearing from you at 2 o'clock.